In just 42 seconds, a freshman congresswoman was about to expose what many believe is the most politically charged Department of Justice in modern American history. Representative Jasmine Crockett didn't come with prepared remarks. She came with receipts. Attorney General Merrick Garland sat at the witness table, his face unreadable, his hands folded. He had no idea what was coming. The cameras were rolling, members of Congress leaned forward in their seats, and in those 42 seconds, Crockett would ask 3 questions that would send shockwaves through the chamber, ignite a firestorm on social media, and force America to confront an uncomfortable truth about equal justice under the law. What happened next wasn't just a hearing, it was a reckoning. This is the story of how one confrontation exposed the deep fractures in American justice, and why what happened in those 42 seconds will be talked about for years to come. Before we understand the eruption, we need to understand the pressure cooker. The House Judiciary Committee hearing on May 15, 2024, was supposed to be routine oversight. Attorney General Merrick Garland's annual testimony, standard questions about budget allocations, crime statistics, departmental priorities. Washington insiders expected a sleepy afternoon of political theater. They were catastrophically wrong. The tension had been building for months. Conservatives accused the Department of Justice of weaponization against political opponents. Progressives claimed the DOJ wasn't doing enough to hold powerful figures accountable. And sitting in the eye of this storm was Merrick Garland, the man who many Republicans still viewed as a stolen Supreme Court nominee, now wielding the full power of federal law enforcement. But there's something you need to understand about Jasmine Crockett. She wasn't your typical freshman representative trying to make a name for herself with viral moments. She was a civil rights attorney from Dallas, Texas. She'd spent years in courtrooms watching the justice system work one way for some people and another way for others. She knew the law, she knew the statistics, and she was done being polite about it. The hearing had already been contentious. Republican members had grilled Garland about the prosecution of January 6 defendants. They questioned the timing of indictments against former President Trump. They accused him of running a 2-tiered justice system. Garland had maintained his composure throughout. His responses were measured, legalistic, carefully constructed to reveal nothing. He cited ongoing investigations. He referenced prosecutorial independence. He deployed the bureaucratic shields that Justice Department officials have perfected over decades. But Crockett had been sitting quietly, watching, waiting. She had 5 minutes allocated for her questioning. She was going to make every second count. The chairman recognized her. The gentlewoman from Texas is recognized for 5 minutes. The room settled. A few members checked their phones, expecting another round of partisan sparring. The C-SPAN cameras continued their steady documentation. Congressional staffers prepared to fact-check whatever claims would emerge. Nobody was prepared for what came next. Jasmine Crockett didn't ease into her questioning. She detonated it. Attorney General Garland, she began, her voice steady and prosecutorial. I want to talk about equal justice under the law. Those words are carved into the front of the Supreme Court building. They're supposed to mean something. So let me ask you this. When a wealthy white-collar executive commits bank fraud involving millions of dollars, what's the average sentence they receive? Garland began to respond, citing the complexity of sentencing guidelines, but Crockett cut him off. Let me help you, Attorney General. According to the United States Sentencing Commission's own data, the average sentence is 14 months.
Now let me ask you this. When a black man with no prior record is caught with a small amount of crack cocaine, what's his average sentence?
The room had gone completely silent. This wasn't the question anyone expected. Garland's expression shifted slightly. Congresswoman, sentencing disparities are a documented concern, and we've taken steps through our prosecutorial policies to 5 years, Attorney General. 5 years for a substance that's pharmacologically identical to powder cocaine, which carries dramatically lighter sentences. Can you explain to me how that represents equal justice? And then came the moment that would define the hearing. Crockett leaned forward, her eyes locked on Garland. You've been Attorney General for over 3 years now. In that time, your department has prosecuted over 1,200 January 6th defendants. Many have received significant prison sentences. I'm not disputing their guilt, but I want you to look at me and explain why. In those same 3 years, not a single police officer has been federally charged in the killing of Breonna Taylor. Not one. Not the officers who executed a no-knock warrant at the wrong apartment. Not the officers who fired blindly into her home. Not the supervisors who approved the operation. Nobody. 42 seconds. That's how long it took for Jasmine Crockett to completely reframe the conversation. The reaction was immediate and explosive. Republican committee members erupted in protest. "Point of order," someone shouted. "This is outside the scope of this hearing." Another yelled. Democrats applauded. The chairman's gavel came down repeatedly, sharp cracks attempting to restore order. Garland sat frozen, his practiced composure momentarily shattered. But Crockett wasn't done. As the chaos settled, all eyes turned to Merrick Garland. This was his moment. How he responded would define not just this hearing, but potentially his entire tenure as Attorney General. He took a breath. When he spoke, his voice was measured, but you could hear the tension beneath it. "Congresswoman, I understand the frustration behind your question. The Breonna Taylor case is a tragedy. It represents systemic issues in policing that go far beyond any single incident. But I need to be very clear about the facts." The room leaned in. This was no longer political theater. This was real. The Department of Justice conducted an extensive investigation into the shooting of Breonna Taylor. We examined thousands of documents, interviewed dozens of witnesses, and consulted with forensic experts. The conclusion of our career prosecutors, based on the evidence and the applicable law, was that we could not prove beyond a reasonable doubt that the officers who fired the fatal shots violated federal criminal civil rights statutes. Crockett interrupted. "Attorney General, with all due respect, that sounds like you're telling the family of Breonna Taylor that their daughter's killing was legal. Is that what you're saying?" The temperature in the room rose again. Republican members tried to interject, claiming Crockett was badgering the witness. Democrats defended her right to follow up. The chairman struggled to maintain control. Garland continued, his words careful but clearly affected. "What I'm saying, Congresswoman, is that there's a difference between something being morally wrong, systemically wrong, and criminally prosecutable under federal law. Federal civil rights statutes require us to prove that officers willfully deprived someone of their rights. That means we must prove they intended to violate the law, not just that they made mistakes or exercised poor judgment." "But you charged Brett Hankison," Crockett pressed. "You charged one officer. So clearly you found some criminal conduct. We charged Detective Hankison with federal civil rights violations for blindly firing 10 rounds into Miss Taylor's apartment. Rounds that went into a neighboring unit and endangered 3 people. That conduct met the legal standard because it was so reckless and indifferent to human life that it rose to the level of willful deprivation of rights."
And what about the other officers? The ones whose bullets actually killed her?
This was the question that millions of Americans wanted answered. The room went silent again. Garland's response would become one of the most analyzed moments of his tenure under Kentucky's self-defense laws and the specific circumstances of that night, including the fact that Miss Taylor's boyfriend fired first. We could not disprove that the officers reasonably believed they were returning fire in self-defense. I know that answer is insufficient for many people. It's insufficient for me personally. But as Attorney General, I must follow the law as it exists, not as I wish it were. That last sentence, "as it exists, not as I wish it were," would be clipped, shared, and debated across every platform for days. But here's what most coverage of this moment missed. What happened in those 42 seconds wasn't really about Breonna Taylor or January 6th or even Merrick Garland himself. It was about something much deeper. The fundamental question of whether America actually has equal justice under the law, or whether that's just something we tell ourselves. Let's examine the evidence, because the numbers are staggering. According to data from the United States Sentencing Commission, Black Americans receive sentences that are on average 19.1% longer than white Americans for the same crimes. That's not historical data from the Jim Crow era. That's current data from the past 5 years. When you control for criminal history, severity of offense, and other relevant factors, the disparity remains, but it goes deeper than sentencing. A comprehensive study published in the Proceedings of the National Academy of Sciences found that about 1 in 1,000 black men can expect to be killed by police over the course of their lifetime. For white men, it's about 39 out of 100,000. That's a rate 2.5 times higher. And prosecutions? Between 2005 and 2020, only 140 police officers were arrested for murder or manslaughter, resulting from on-duty shootings. Out of thousands of fatal police shootings, of those 140, only 44% were convicted. And of those convictions, many resulted in reduced charges or minimal sentences. Compare that to the aggressive prosecution of other crimes. The DOJ has brought over 1,265 cases related to January 6th. They've achieved a conviction rate of over 99%. The average sentence for those convicted has been approximately 3 years, with some defendants receiving sentences of up to 20 years. Now let me be clear. I'm not suggesting January 6 defendants shouldn't be prosecuted. What happened that day was an attack on American democracy, and those responsible should face consequences. But Crockett's question exposed the uncomfortable truth. The Department of Justice can achieve nearly perfect conviction rates and significant sentences when it wants to, when it makes something a priority. So why hasn't police accountability been that same priority? Within minutes of the exchange, social media exploded. Within hours, it had fractured along predictable but deeply revealing lines. Conservative commentators accused Crockett of race-baiting and undermining law enforcement. Ben Shapiro released a video titled "Democrat Congresswoman Compares Patriots to Cops Who Kill." Tucker Carlson dedicated a segment to what he called the Democrats' war on police. The National Police Association called for a formal censure of Crockett. On the left, the response was completely different. The squad members Alexandria Ocasio-Cortez, Ilhan Omar, and Rashida Tlaib all shared clips of the exchange. Crockett Speaks Truth trended on Twitter for 3 days. Civil rights organizations praised her for finally asking the questions that need to be asked. Legal scholars debated the prosecutorial standards Garland had outlined. But here's what's fascinating. Neither side really engaged with the substance of her question. Conservatives focused on defending police officers broadly. Progressives focused on attacking the justice system broadly. Almost nobody addressed the specific legal and evidentiary challenges that Garland had outlined. Because the truth is complicated, and our political discourse has no room for complications. The reality is that federal civil rights prosecutions of police officers are incredibly difficult to win. The legal standard, willful deprivation of rights, sets an extraordinarily high bar. Prosecutors must prove not just that an officer used excessive force, but that they intended to violate someone's constitutional rights. That's a nearly impossible standard when officers can claim they feared for their safety, made split-second decisions, or followed their training.
This isn't a defense of the standard. Many legal experts argue it should be changed.
But it is the reality that any attorney general, regardless of party, faces. Yet here's the uncomfortable question that Crockett's confrontation raised. If the legal standard is too high to successfully prosecute police officers, why hasn't the Department of Justice made changing that standard a legislative priority? Why hasn't Garland testified before Congress requesting amendments to Section 242 of Title 18, the federal criminal civil rights law? The answer reveals something important about how power actually works in Washington. Police unions are politically powerful. Police officers are generally popular with the public. Prosecutors, including the Attorney General, often see themselves as part of the broader law enforcement community, and changing federal criminal statutes requires Congress, which means navigating political minefields. So instead, we get what happened in that hearing: passionate questions, careful answers, and ultimately no change at all. To truly understand this moment, we need to understand Merrick Garland's journey to that witness table, because his story is inextricably tied to the politicization of justice in America. In 2016, Supreme Court Justice Antonin Scalia died. President Obama nominated Merrick Garland, a moderate judge with a sterling reputation, to fill the vacancy. Under normal circumstances, he would have been confirmed. He was respected by both parties. His judicial record was mainstream. Even many Republicans had previously praised his qualifications. But Senate Majority Leader Mitch McConnell made a calculated decision, refused to even hold hearings. His reasoning? It was an election year, and the American people should have a voice in the selection of their next Supreme Court justice. That decision broke decades of Senate norms. Garland's nomination languished for 293 days. No hearings, no vote, just political obstruction. When Trump won the election, he nominated Neil Gorsuch instead. Conservatives gained a Supreme Court seat through pure political hardball. 4 years later, when Justice Ruth Bader Ginsburg died just 46 days before the 2020 election. McConnell reversed his position entirely. Amy Coney Barrett was nominated and confirmed in record time. The hypocrisy was stunning, but the political calculation was clear. Power matters more than principle. This background is crucial because when Biden nominated Garland as Attorney General in 2021, Republicans saw it as political payback. Democrats saw it as justice delayed. And Garland himself carried the weight of being denied what many considered his rightful place on the Supreme Court. From the moment he was confirmed, Garland faced impossible expectations. Democrats wanted aggressive prosecution of Trump and January 6th participants. Republicans accused him of weaponizing the DOJ for political purposes. Civil rights advocates demanded accountability for police violence. Law enforcement organizations wanted support against what they called anti-police rhetoric. No person could satisfy all those constituencies. But Garland tried to thread the needle. He appointed Jack Smith as special counsel to investigate Trump, creating independence from direct political control. He oversaw the largest criminal investigation in DOJ history, targeting January 6th participants. He launched pattern or practice investigations into multiple police departments. He spoke frequently about his commitment to civil rights. But for many, including Jasmine Crockett, it wasn't enough. Because while Garland could point to institutional reforms and policy changes, the high-profile criminal accountability that communities demanded rarely materialized. The Breonna Taylor case exemplified this frustration. The DOJ investigation took over a year. It resulted in civil rights charges against 4 officers, but those charges focused on the warrant application process and the excessive force, not the killing itself. Brett Hankison was tried twice on federal charges. The first trial ended in a mistrial, the second in acquittal on some counts. The outcomes felt inadequate to a grieving family and a community demanding justice. Let's talk about something most people don't understand. Why prosecuting police officers is so uniquely difficult in America. Because Garland's defense, whether you accept it or not, is rooted in very real legal constraints. The primary federal statute for prosecuting civil rights violations by police officers is 18 U.S.C. Section 242. It makes it a crime to willfully deprive someone of their constitutional rights under color of law. Sounds straightforward, right? It's not. That word willfully is the killer. The Supreme Court has interpreted it to require proof that the officer knew their conduct was unlawful and chose to do it anyway. Not that they should have known. Not that a reasonable officer would have known, that they actually knew and intended to violate someone's rights. Imagine trying to prove that in a split-second police shooting, the officer says, "I feared for my life. I thought they had a gun. I was trained to shoot in that situation." Even if their fear was unreasonable, even if they made catastrophic mistakes, if you can't prove they intended to violate rights, the case fails. This standard comes from a 1945 Supreme Court case called Screws v. United States. In that case, a Georgia sheriff beat a black man to death. The Supreme Court overturned the conviction because the trial court hadn't properly instructed the jury about the willfulness requirement. The court was worried that without this high standard, federal prosecution of police officers would be based on mere errors in judgment rather than intentional civil rights violations. But here's the problem. That standard made sense in 1945 when federal prosecution of local police officers was rare and controversial. In 2024, it creates near immunity for police violence. Officers just need to say they believe their actions were lawful, and suddenly the federal government can't touch them, even in egregious cases. State prosecutions face different but equally daunting challenges. Prosecutors work closely with police on every case. They depend on police testimony to convict defendants. That creates powerful institutional pressure not to prosecute cops. Plus, juries are typically sympathetic to police officers. They're seen as public servants who risk their lives daily. Convincing a jury to convict an officer, especially when the officer claims they feared for their safety, is incredibly difficult. The numbers bear this out. From 2005 to 2020, there were over 15,000 fatal police shootings in America. Approximately 140 officers were arrested for murder or manslaughter. That's less than 1%. Of those 140 arrests, only 44% resulted in convictions, and many of those convictions were for lesser charges with minimal sentences. But here's what Crockett was really asking. If the system is broken, if the legal standards make accountability nearly impossible, why isn't fixing that the DOJ's top priority? Why are we spending enormous resources prosecuting January 6th cases, which are admittedly important, while telling victims of police violence that the law just doesn't allow for justice? That question doesn't have a comfortable answer, because the truth is that fixing it would require taking on powerful interests, spending significant political capital, and fighting for legislative change that might fail. It's easier to work within the broken system and explain why certain cases can't be brought than to actually reform the system. We need to talk explicitly about race, because that was the subtext of Crockett's entire line of questioning. And in America, we're really bad at having honest conversations about race and justice. Let me share some data that makes people uncomfortable. Black Americans make up about 13% of the U.S. population, but 33% of the federal and state prison population. Latino Americans are 18% of the population, but 23% of the prison population. White Americans are 60% of the population, but only 30% of the prison population. Now, some will argue this reflects different crime rates, but here's the thing. When you control for the same crimes, the disparities persist. A comprehensive study by the U.S. Sentencing Commission found that black men receive federal sentences that are on average 19.1% longer than white men for the same crimes with similar criminal histories. The war on drugs exemplifies this perfectly. Crack cocaine and powder cocaine are pharmacologically the same drug, but for decades, crack possession carried sentences 100 times longer than powder cocaine. Pure coincidence that crack was associated with black communities and powder cocaine with white users? The Anti-Drug Abuse Act of 1986, which created this disparity, was passed during the height of drug war hysteria. It was sold as tough-on-crime policy, but its impact was devastating and racially skewed. Congress partially addressed this with the Fair Sentencing Act of 2010, reducing the disparity from 101 to 18:1. But even that reform maintains a massive sentencing gap for chemically identical substances, and Garland's DOJ hasn't made eliminating the remaining disparity a priority. Then there's marijuana. As states have legalized it, mostly white entrepreneurs have built billion-dollar cannabis businesses. Meanwhile, thousands of people, disproportionately black and Latino, remain in prison for marijuana offenses that are no longer crimes in many states. Garland has supported pardons for federal simple marijuana possession, but that affects relatively few people. Most marijuana convictions are at the state level, outside his direct authority. But here's the deeper issue. Systemic racism in justice isn't always, or even usually, about explicit racial animus. It's about systems that were built in racist eras and never fully reformed. It's about prosecutors who aren't racist, but who have internalized stereotypes about which defendants are dangerous. It's about algorithms that predict recidivism, but are trained on historical data that reflects decades of discriminatory policing. It's about bail systems that disadvantage poor defendants, who are disproportionately black and brown. When Crockett confronted Garland about equal justice, she wasn't just asking about specific cases, she was asking why the entire architecture of American criminal justice still produces racially disparate outcomes, and why the Department of Justice isn't treating that as a crisis requiring urgent systemic reform. In the days following the hearing, the political battles intensified, but something else happened that received less attention. Conversations started happening in living rooms, workplaces, and classrooms across America. Teachers in high school government classes showed the clip and asked students to debate whether Crockett's question was fair. Law school professors assigned it in criminal procedure courses and asked students to brief the relevant statutes. Families had uncomfortable conversations about police violence and racial justice over dinner. This is what accountability moments can do. They force us to confront questions we'd rather avoid. They make the abstract concrete. Instead of debating systemic racism in the abstract, people were discussing specific cases, specific laws, specific disparities. But the establishment response was telling. The DOJ issued a carefully worded statement defending Garland's testimony and emphasizing the department's commitment to civil rights enforcement. They cited statistics about pattern or practice investigations, grants for police reform, and civil settlements in police misconduct cases, all of which is true. The DOJ under Garland has opened investigations into police departments in Minneapolis, Louisville, Phoenix, and several other cities. They've reached consent decrees requiring reforms. They've provided funding for de-escalation training and body cameras. But here's what critics noted. All of those are institutional reforms. They're about changing policies and practices. They rarely result in individual officers going to prison for killing civilians. And for many people, particularly in communities that have lost loved ones to police violence, institutional reform without individual accountability feels like justice denied. Representative Crockett followed up her hearing questioning with a written letter to Garland, which was released publicly. In it, she pressed for specific answers. How many police officers has the DOJ prosecuted for excessive force resulting in death since Garland became Attorney General? What is the conviction rate in those cases? How many cases were declined for prosecution, and what were the reasons? The DOJ's response, when it came weeks later, was heavily redacted and cited ongoing investigations for many of the details Crockett requested. This is standard practice to protect prosecutorial independence and ongoing cases. But it frustrated transparency advocates who argued the public has a right to know how their Justice Department is handling police accountability. Meanwhile, conservative media had moved on to other outrages. Progressive media continued covering the issue, but without the viral intensity of the initial moment. And in Washington, the machinery of government continued as it always does, slowly, bureaucratically, resistant to fundamental change. Let's zoom out and ask the fundamental question. Does America actually have equal justice under the law? Because that's what this entire confrontation was really about. The honest answer is complicated. On paper, yes, the Constitution guarantees equal protection. The law applies to everyone. Courts are supposed to be blind to race, wealth, and status. But in practice, the data suggests something very different. If you're wealthy and accused of a crime, you can afford the best lawyers. You can hire investigators, expert witnesses, jury consultants. You can fight the charges for years if necessary. You'll probably make bail easily. And if you're convicted, your attorney will present mitigating evidence about your good character, your family responsibilities, your contributions to society. If you're poor and accused of the same crime, you'll probably get an overworked public defender who has hundreds of cases and barely any time for yours. You might not make bail because you can't afford it, so you'll sit in jail for months or years before trial, losing your job and housing. You'll probably take a plea deal even if you have a viable defense because the risk of trial is too great. And if you're convicted, the judge will see someone with a criminal record, unstable housing, and limited community ties. This isn't theory. A 2016 study by the Courtroom Center for the Fair Administration of Justice found that defendants who are detained pre-trial because they can't afford bail are significantly more likely to be convicted and receive longer sentences than similar defendants who make bail. The punishment begins before the trial even happens. And that's before we add race to the equation. Study after study has found that Black and Latino defendants receive harsher treatment at every stage of the criminal justice process. More likely to be stopped by police. More likely to be arrested, rather than released with a warning. More likely to be charged with serious offenses. Less likely to receive favorable plea deals. More likely to be detained pre-trial. More likely to be convicted. And more likely to receive longer sentences. Is this because of individual racist judges and prosecutors? Sometimes, but that's not the main driver. The main driver is systemic. How discretion is exercised, how risk is assessed, how credibility is judged, how resources are allocated. When all of those micro-decisions are made by people who have internalized societal biases, even unconsciously, the system produces unequal outcomes even without anyone intending it. So what does equal justice actually require? At minimum, it requires that people accused of the same crime with the same criminal history receive roughly similar treatment and sentences regardless of their race or wealth. We are nowhere close to that reality. But Crockett's question pushed even further. Does equal justice require that police officers face the same accountability for violence as civilians? Right now, they don't. Police officers have qualified immunity in civil cases, making them hard to sue. They have strong union protections, making them hard to fire. And they have the willfulness standard in criminal cases, making them hard to prosecute. Is that inequality justified because policing is difficult and dangerous? Or is it a form of aristocracy where one group is above the law? So what are the solutions? Because pointing out problems is easy, fixing them is hard, and the honest solutions are politically toxic. Let's start with the police accountability issue. If we want to make it easier to prosecute officers who use excessive force, we need to change the legal standard. That means amending 18 U.S.C. Section 242 to remove or modify the willfulness requirement. Instead, the statute could require proof of reckless disregard for constitutional rights or objectively unreasonable force. This would align federal law with what most reasonable people think the standard should be. Officers should be prosecuted when they use force that a reasonable officer wouldn't use in that situation, regardless of their subjective intent. It would still protect officers who make good faith mistakes in genuinely ambiguous situations. But it would eliminate the defense that I thought I was allowed to do it in cases where the officer's belief was unreasonable. But here's the political reality. Police unions would fight this ferociously. Many Democrats would be afraid to support it, worried about being labeled anti-police. Republicans would oppose it almost unanimously. And even if it somehow passed, expect a Supreme Court challenge arguing it violates federalism by intruding on state sovereignty over local policing. What about sentencing disparities?
The solution is relatively straightforward. Mandatory sentencing guidelines that remove discretion. If everyone convicted of the same crime with the same criminal history must receive the same sentence, disparities disappear. But wait, we tried this. The federal sentencing guidelines enacted in the 1980s were supposed to accomplish exactly this, and they did reduce disparity to some extent, but they were so rigid that judges hated them. In 2005, the Supreme Court made them advisory rather than mandatory. Discretion returned, and so did disparities. The truth is that both extremes are problematic. Rigid, mandatory sentences prevent judges from considering individual circumstances and lead to unjust outcomes, but unrestricted discretion allows bias, conscious or unconscious, to influence outcomes. The answer is probably somewhere in the middle. Guidelines with limited flexibility, subject to review for consistency. What about wealth disparities? This requires confronting our bail system. Right now, we have a system where dangerous people sometimes go free because they're wealthy, while non-dangerous people sit in jail for months because they're poor. That's indefensible. The solution is risk-based detention.
Judges should assess whether someone is a flight risk or a danger to the community. If yes, they're detained. If no, they're released, regardless of wealth. But this would eliminate the bail bonds industry, which is politically powerful and has fought these reforms aggressively. And it would require significant investment in pretrial services to conduct risk assessments and monitor released defendants. What about the crack powder sentencing disparity? Just eliminate it entirely. Make the penalties identical. This is the easiest of all the solutions, with the least justification for the current system. But it hasn't happened because Congress is terrified of being seen as soft on drugs, even though the disparity has no rational basis. And what about the thousands of people currently in prison under the old unjust standards? They should be resentenced under the new standards. This is called retroactivity, and we've done it before with some sentencing reforms, but it requires political will and judicial resources. Here's the fundamental problem. All of these solutions require people in power to give up power. Prosecutors would have less discretion, police would have less immunity, wealthy defendants would have less advantage. And the systems that currently benefit from injustice, the bail bonds industry, private prisons, police unions, would fight to preserve the status quo. Let's return to that moment. 42 seconds, 3 questions. 1, freshman congresswoman, and the Attorney General of the United States. What did Jasmine Crockett actually accomplish in that exchange? Because viral moments are fleeting, outrage fades, the news cycle moves on, did anything actually change? On one level, the answer is no. No laws were passed because of that hearing. No major policy changes were announced. Breonna Taylor's family still doesn't have the criminal accountability they sought. The systemic issues Crockett highlighted still exist. But on another level, something significant happened. Crockett forced a conversation that powerful people didn't want to have. She made millions of Americans confront the gap between our ideals and our reality. She gave voice to frustrations that many people feel but struggle to articulate. And she did something else. She demonstrated what actual oversight looks like. Not performative outrage designed to generate clips for fundraising emails, not partisan point scoring. But serious, informed questioning that holds power accountable. Because here's what made Crockett's questioning effective. She knew the law. She cited specific data. She asked questions that had no good answers. She didn't grandstand or make speeches. She asked 3 questions that exposed an uncomfortable truth. The Department of Justice can aggressively prosecute when it wants to, but it often doesn't want to when the defendants are police officers. Garland's response, careful and legalistic as it was, essentially confirmed this. He could have said, "You're right, the system is broken, and I'm working to fix it." He could have outlined specific legislative proposals he's advocating for. He could have announced new initiatives to address these disparities. Instead, he defended the status quo. He explained why the current system constrains him. He cited the law as it exists, not as it should be, and in doing so, he confirmed what critics have long argued. The Justice Department, even under the most well-intentioned leadership, is more committed to institutional stability than to transformative change. This doesn't make Garland a villain. By all accounts, he genuinely cares about civil rights. He's spent his career in public service. He believes in the rule of law, but that's precisely the point. Even good people working within bad systems will produce unjust outcomes unless the system itself changes. Behind all these statistics and legal arguments are human beings, real people whose lives have been destroyed by a system that doesn't see them as fully human, fully deserving of justice. Breonna Taylor was a 26-year-old emergency medical technician. She worked saving lives. On March 13, 2020, police executing a no-knock warrant broke down her door after midnight. Her boyfriend, Kenneth Walker, thought they were intruders and fired 1 shot. Police fired 32 shots in response. 6 hit Breonna. She died in her hallway. The warrant was for her ex-boyfriend who didn't live there and had already been arrested elsewhere. The raid was based on the suspicion that Breonna was receiving packages for him, which she wasn't. The officers didn't find any drugs or evidence in her apartment. They killed an innocent woman based on bad information. Her mother, Tamika Palmer, spent years fighting for accountability. The city of Louisville settled her civil lawsuit for $12 million, one of the largest settlements in history for a police killing. But money doesn't bring back a daughter, and without criminal accountability, the settlement feels like the government putting a price tag on a black woman's life. When Tamika Palmer heard Garland's testimony explaining why officers couldn't be prosecuted for killing her daughter, she released a statement. They say the law doesn't allow them to charge the officers who killed Breonna, then the law is broken, and the people who enforce that law have blood on their hands. Those words haunted Garland. Sources inside the Justice Department said he personally agonized over the Taylor case. He understood the family's pain, but he also believed that prosecutors must follow the law, even when the law produces unjust outcomes. For Garland, that tension between moral conviction and legal constraint defined his entire tenure. But Breonna Taylor isn't the only name. There's George Floyd, killed by Minneapolis officer Derek Chauvin, who knelt on his neck for over 9 minutes. That case did result in both state and federal convictions, but only because the killing was captured on video that went viral and sparked global protests. Without that video, without that pressure, would justice have been served? There's Eric Garner, killed by NYPD officers using an illegal chokehold, his last words, "I can't breathe," captured on video. A grand jury declined to indict. Federal prosecutors declined to bring charges. There's Tamir Rice, a 12-year-old boy killed by Cleveland police within 2 seconds of their arrival because he was playing with a toy gun. No charges. There's Philando Castile, killed during a traffic stop. After informing the officer he had a legally permitted firearm, the officer was acquitted. No federal charges. There's a Tatiana Jefferson, killed in her own home by a Fort Worth officer who was responding to a welfare check. The officer was indicted for murder, but the case ended in mistrial, and then he was convicted of manslaughter and sentenced to less than 12 years. There's Botham Jean, killed in his own apartment by an off-duty Dallas police officer who claimed she thought it was her apartment. She was convicted of murder and sentenced to 10 years, but many questioned whether she would have received the same leniency if the races were reversed. Each of these names represents a family that will never be whole again, a life cut short, a future stolen, and in almost every case, the justice system failed to provide accountability. But let's be fair, we need to examine the other side of this debate, because there are serious people making serious arguments about why police accountability is complicated. Police officers do have one of the most difficult jobs in society. They're asked to run toward danger when everyone else runs away. They face life-threatening situations where they have split seconds to make decisions. A mistake by a police officer can result in their own death or the death of their partner. According to the FBI's law enforcement officers killed and assaulted report, an average of 60 officers are feloniously killed in the line of duty each year. Thousands more are assaulted. They work in an environment where routine traffic stops can turn deadly, where welfare checks can become violent confrontations, where the person they're trying to help might attack them. Supporters of police argue that Monday morning quarterbacking these split-second decisions from the safety of a courtroom is fundamentally unfair. They point out that officers are trained to perceive threats and respond quickly. In the moment, with adrenaline pumping and limited information, officers must make choices that look different in hindsight than they did in real time. There's also the argument about deterrence. If we make it too easy to prosecute police officers, some argue good officers will leave the profession or become passive in their duties. They'll hesitate in situations where hesitation could get them killed. Crime will increase as proactive policing decreases. Some data appears to support this concern. After high-profile police killings and subsequent protests, some cities have experienced what's called the Ferguson effect. Officers pulling back from proactive enforcement, leading to temporary increases in some crimes. Furthermore, defenders argue that the bad apple narrative is overblown. Most officers never fire their weapon in the line of duty. Most complete entire careers without being involved in a shooting. The officers who are involved in multiple questionable incidents are a small percentage of the overall force. These are not illegitimate concerns. The question is whether they justify the current state of near-zero accountability. Because here's the thing, we can acknowledge that policing is difficult while still demanding accountability for egregious violations. These aren't mutually exclusive positions. In fact, most police officers would tell you that bad cops make their jobs harder by eroding public trust. The case for reform doesn't require believing that all or even most police officers are bad people. It requires believing that systems without accountability inevitably produce abuse. This is true for any profession with power over others. Doctors, lawyers, politicians, and yes, police officers. Moreover, the comparison between police killings and officers killed in the line of duty is revealing. About 60 officers are killed feloniously each year. About 1,000 civilians are killed by police each year, even accounting for the fact that many of those police killings are justified. The disparity is stark, and the deterrence argument, while theoretically plausible, lacks strong empirical support. Many other developed democracies have stricter accountability for police officers, and they don't experience the problems that American police advocates predict. In the UK, Germany, and Japan, for example, police officers face criminal prosecution for excessive force at much higher rates than in the US, yet these countries maintain effective law enforcement and lower crime rates. Let's look at how other countries handle police accountability, because America's approach is actually quite unusual in the developed world. In England and Wales, when police officers use lethal force, it's automatically referred to the Independent Office for Police Conduct, which investigates completely separately from the police department. If criminal charges are warranted, they're brought by the Crown Prosecution Service, not by prosecutors who work daily with police. The numbers are striking. British police killed 3 people in 2019. 3. In a country of 67 million people, American police killed over 1,000 people that same year. In a country of 330 million, even adjusting for population, American police kill at a rate more than 10 times higher. Why? Part of it is guns. America has far more armed civilians, which creates more dangerous situations for police. But that's not the whole story. British police also face armed suspects. They just handle situations differently. They're trained in extensive de-escalation. They view lethal force as an absolute last resort. And they know that if they use force inappropriately, they'll face serious consequences. Germany provides another interesting comparison. German police killed 14 people in 2019. Again, far fewer than the US. Even accounting for population differences, German police academies require 3 years of training compared to an average of 21 weeks in the United States. That training emphasizes psychology, ethics, and de-escalation alongside tactical skills. And when German police do use excessive force, prosecutors are much more aggressive. A 2017 study found that German prosecutors bring charges in police shooting cases at rates far higher than American prosecutors. The legal standard is also different. Officers must prove their force was necessary rather than prosecutors proving it was willful. Japan is perhaps the most extreme example. Japanese police killed 3 people in 2018. 3. In a country of 126 million people, Japanese police fired their weapons only 6 times total that year. This is partly cultural. Policing in Japan is viewed as a profession requiring extreme restraint and discipline, but it's also structural. Officers face serious consequences for inappropriate force, and the social shame associated with such violations is intense. Now, some will argue that these comparisons are unfair. America is more diverse, more armed, more violent than these other countries. American police face challenges that British or German or Japanese police don't face. There's truth to this, but it doesn't explain the entire gap, because even when you compare similar situations, American police use lethal force more frequently. The cultural and legal framework around American policing simply accepts a level of violence that other developed democracies find unacceptable. And here's the key point. Those other countries maintain effective law enforcement. Crime is not running rampant in Britain because they hold police accountable. Germany hasn't descended into chaos because officers face prosecution for excessive force. The prediction that accountability will destroy policing is not supported by international evidence. So, if reform is possible, if other countries prove it works, why hasn't America done it? The answer is institutional resistance, because changing systems requires overcoming the people and organizations that benefit from the current system. Police unions are among the most powerful political forces in America. They donate heavily to political campaigns, usually but not exclusively to Republicans. They have strong grassroots organizing capacity. They can run attack ads against reform-minded candidates. And they're not shy about using that power. When cities or states attempt police reform, unions typically fight it aggressively. They argue that any changes will endanger officers and embolden criminals. They frame reform as anti-police, and they have deep relationships with media outlets that will amplify their message. The Fraternal Order of Police, the largest police union, has over 356,000 members. When they speak, politicians listen. When they oppose a candidate, that candidate often loses. This political power makes meaningful reform extremely difficult. But it's not just unions. Police departments themselves have institutional cultures that resist accountability. Officers are taught to protect each other. The blue wall of silence isn't just a saying. It's a real phenomenon where officers refuse to testify against colleagues even in cases of obvious misconduct. This culture starts in training. Police academies emphasize the dangers of the job, the US versus them mentality. The idea that only another officer can understand what you're going through. These aren't inherently bad messages. Policing is dangerous and officers do need to trust their partners. But it creates an environment where loyalty to fellow officers outweighs honesty and accountability. Prosecutors are another source of institutional resistance. Remember, prosecutors work with police every single day. They depend on police testimony to convict defendants. If a prosecutor aggressively goes after cops, will the police department still cooperate on their other cases? Will officers still show up to testify? Will they gather evidence as carefully? These aren't hypothetical concerns. Prosecutors who have tried to hold police accountable report retaliation. Officers who forget key details. Investigations that somehow stall. Witnesses who aren't found. The institutional pressure not to prosecute police is immense. This is why calls for independent prosecutors in police shooting cases have gained traction. The idea is that someone without daily working relationships with police should make charging decisions. Several states have implemented this reform, but even independent prosecutors face challenges. They still need police cooperation in investigations. They still need to prove cases to juries that are often sympathetic to police.
The judiciary also plays a role. The Supreme Court has created doctrines like qualified immunity that make it extremely difficult to sue police officers for misconduct, unless the specific constitutional violation was clearly established by previous cases. Officers are immune from civil liability. This means that officers can violate rights in creative new ways and face no consequences because no previous court had specifically said that exact conduct was unconstitutional. This doctrine was created by courts concerned about frivolous lawsuits against officers, but it's grown into a shield against accountability. Even egregious misconduct often gets dismissed on qualified immunity grounds. And the Supreme Court has shown no appetite for reforming this doctrine, despite bipartisan criticism. This brings us back to Merrick Garland and the political calculations that shape justice in America. Because Garland isn't naive. He understands all of this, so why hasn't he made police accountability reform his signature issue? The answer is political calculus. The Attorney General is nominated by the President and confirmed by the Senate. Both are political processes. The DOJ's budget is set by Congress. High-profile prosecutions are scrutinized by politicians and media. Everything the Attorney General does has political implications. If Garland had come into office and immediately announced aggressive prosecution of police officers, the political blowback would have been intense. Police unions would have revolted. Republican politicians would have accused him of waging war on law enforcement. Fox News would have made him the villain du jour.
and moderate Democrats in competitive districts would have distanced themselves. Is this fair? No. Should the Attorney General make decisions based on law and evidence rather than politics? Yes. But the reality is that political considerations shape prosecutorial priorities. They always have. Look at the January 6th prosecutions that Crockett compared to police accountability. Why did the DOJ make January 6th such a priority? Partly because it was an attack on democracy that demanded a strong response, but also partly because prosecuting Trump supporters was politically safe for a Democratic administration. The political pressure pushed in the same direction as the legal merits. Police accountability is different. The political pressure cuts both ways. Progressive Democrats want aggressive prosecution, but police unions, moderate Democrats, and most Republicans oppose it. For an attorney general trying to preserve the DOJ's reputation for independence, wading into that fight is dangerous. So Garland has taken a middle path. He's launched pattern or practice investigations, which examine entire police departments and force institutional reforms through consent decrees. He's provided funding for police reform initiatives. He's spoken about the importance of civil rights, but he hasn't pushed for the legal reforms that would fundamentally change accountability, and he hasn't brought high-profile prosecutions, except in the most egregious cases. Is this cowardice, political calculation, or prudent management of limited political capital? Probably all three. Garland likely believes he's being strategic, choosing battles he can win, and avoiding fights that would damage the DOJ's broader mission. But critics like Crockett see it differently. They see an attorney general who is too worried about his reputation, too concerned about institutional stability, too unwilling to spend political capital on behalf of communities that have been demanding justice for decades. And here's the uncomfortable truth. Both perspectives have merit. Garland probably is being too cautious, but he's also operating in a political system that punishes boldness on this issue. He could be more aggressive, but at the cost of other priorities and potentially his position.
Is that trade-off worth it?
Different people will answer that differently.